Hi everyone, and welcome to today's webinar. We're going to get started at once. We'll give some stragglers a couple minutes to get on, but welcome. Hello everyone, and welcome to today's webinar, Clearing the Smoke, Understanding the Implications of Addressing Marijuana When Laws and Regulations Conflict. My name is Grace Rowan, one of the graduate assistants at IHEC, and I'll be your moderator. I am assisting Aisha, the Assistant Director for the Illinois Higher Education Center for Alcohol, Other Drug, and Violence Prevention, and I am very excited to be hosting today's event. Before I hand over the microphone, I have a few housekeeping items to cover about today's webinar and the GoToWebinar platform. For those of you new to using GoToWebinar, you will see the control panel on the right of your screen. This is where you'll find the question box that you can type and submit to at the end of the presentation. All attendees will be muted for today's program, but that does not mean you still can't participate. So without any further ado, I'd like to introduce today's speaker, Dr. Eric Davidson. Dr. Davidson lives in Charleston, Illinois, and has been employed with the Eastern Illinois University since 1996. Eric received his PhD in health education from SIUC in 2012. He also has a master's degree in clinical psychology from Eastern Illinois and a double bachelor's degree in psychology and speech communications, also from EIU. Currently, he is the interim director for EIU's Health and Counseling Services, director of Illinois Higher Education Center for Alcohol, Other Drug, and Violence Prevention, as well as the Student Affairs Assessment Coordinator. Welcome, Dr. Davidson. The stage is yours.
Thank you, Grace. Thank you, everyone, for being here today. Know that this time of year is quite busy for many of us, and there are probably a long list of things that everybody could be doing. So thank you for investing your time into this particular workshop. I'm going to talk a little bit today about marijuana law, why, as institutions of higher education, we're required to comply with federal laws, what those federal laws are, some of the legal precedents that impact the federal law and our compliance with that. And then we'll close out looking at some institutions of how they have handled the issue when their states have legalized marijuana, yet they've had to remain in compliance with the federal law. The misalignment between state law, federal law, local law, and federal law has really created a lot of confusion for us as institutions of higher education. It's created confusion for our students. It's created confusion for the staff that are expected to comply and meet compliance with the Drug-Free Schools and Campuses Act. It's created some issues with security and law enforcement. It's really created a problem, and it's probably the one area that as IHEC we are seeing the most questions and issues coming in. As a result of today, I hope that you'll be able to talk to your colleagues about some of the federal laws and regulations which require us to ignore state and local marijuana cannabis laws, that you'll be able to talk a little bit about the American with Disabilities Act and how that impacts medical marijuana and request for accommodation. Some components of sample policy statements that other institutions have adopted, some considerations for addressing off-campus use by employees and students, And then depending upon the time that we have left today, we'll probably open up the mics to everybody for a group discussion based upon the number of folks that it appears to be attending today. That may be very meaningful. I always like to start this presentation by some history to give some context. The history of marijuana and cannabis use and legalization in the US could be its own presentation. So I've tried to highlight some of the key things that impact where we are today, particularly in higher education. And a starting point is the Controlled Substances Act of 1970. And this really creates the foundation of why we must do what we must do. A lot of times folks will come up to me and say, Eric, we've got to do this because of the Drug-Free Schools and Campuses Act. And that's partially true, but the real foundation of why we do what we do is this Controlled Substances Act, which I'll talk a little bit about a few slides down the road. We first saw legalization of medical marijuana occur in New Mexico in 1978. So when we think about it, 42 years, this issue of medical marijuana has been going on and wavering back and forth. The FDA set up a medical marijuana distribution program that same year. They controlled the cannabis and the marijuana that was being used for that medical marijuana in New Mexico. In the 80s, we have President Reagan assume the presidency. He really wanted to take a hard stance against substance abuse. His wife became an advocate for prevention, and you will see that during the mid 80s, particularly after the beginning of his second term, a whole slew of legislature coming out dealing with substance abuse. The Anti-Drug Abuse Act, which basically reinstated mandatory prison sentences and the three strikes law. And when we talk about social inequities and social justice with relationship to current cannabis laws, the issue of are we being discriminatory? African Americans seem to be being arrested more than Caucasians, and how does that play? And a lot of that will tie back to this Anti-Drug Abuse Act. We also know that in '86, the Drug Free and Safe Communities Act was passed. That provided a foundation, and later on was revised and amended in '89 to include colleges and campuses, and that's where the Drug-Free Schools and Campuses Act comes to play. And then we also have the Drug-Free Workplace Act of 1988. So, you know, these laws have really set the foundation for where we are and what we do today. In 1994, the courts finally came out with a final decision regarding a court battle that had started 22 years earlier regarding the scheduling of marijuana. And that basically said marijuana will stay a Schedule I drug. So, you know, the debate as to whether we have marijuana be a Schedule I drug, we move it to a different schedule, we totally delegalize it and decriminalize it, has been going on really since the 1970s. Almost 50 years. In '96, California became the first state to legalize medical marijuana. And what we see is a proliferation of states moving in that direction from that point. In 2009, we have the Ogden memo, and this memo is probably one of the great changes in how the federal government looked at marijuana, looked at cannabis use, and basically Ogden wrote two memos, and the first one said that government resources shouldn't be directed toward prosecuting medical marijuana users who were in compliance with state laws, and that if anything, the federal government should be focused on those trafficking marijuana. So many took that as a green light for state legalization and commercial dispensaries. The Cole memo came out, and added to that and basically differentiated caregivers from large-scale commercial operations. So they wanted to protect the little guy, those individuals that were using marijuana for medicinal purposes, but they really didn't want to eliminate or avoid prosecution or targeting the larger scale operations. In 2012, Colorado and Washington legalized recreational use. And then in 2013, Cole sent out a second memo. And basically that memo, which created a infrastructure for how the federal government was going to deal with marijuana, basically said legalized states are not going to be a priority as long as they are regulating the marijuana use. If there were going to be any areas of prosecution, they were going to focus on things such as underage use. In 2014, we have the Rohrabacher-Farr Amendment, which basically required an annual renewal and prohibited the Justice Department from interfering with the implementation of state medical cannabis laws. So at the federal level, there was this movement to be more lenient, to be more permissive. But interestingly, none of the federal pieces of legislation impacted the Controlled Substance Act, the Drug-Free Schools and Campuses Act, the Safe and Drug-Free Communities Act, the things that really rely on us, that we rely on for our guidance. In 2018, after President Trump entered the White House, Sessions rescinded the second Cole memo. Some have looked at that as negative. Others have said, well, it really hasn't changed the practice of the federal government, so it's not that big of a deal. Really, time will tell to see what the final impact of that rescission is. So it is a changing landscape. As of December, 16 states allowed medical CBD use. One of the things that I often get asked is, oh, CBD use, that's legal, right? And it's not necessarily the case. In about 18 months ago, the feds made some modifications to the Drug Enforcement Agency and the FDA, basically saying that certain medications containing CBD would be permitted. Those medications are very specific. It is a small number that are regulated. They are mainly intended as medications for the addressing of seizures. Again, a very small number. So really, when you look out and about and you see all the CBD advertisements and things like that, the feds still will sit there and say that is cannabis and that is illegal. 32 states allow medical marijuana, 13 have decriminalized marijuana, and 10 have actually passed legalization. So if you look at the slides, you can see a map here. These are the states that have medical CBD. These are the states that have medical marijuana. You will notice in our region, the only border state that currently has that as of December would have been Missouri. When we look at decriminalized, again, Missouri at that time when I originally created this workshop was the original state that had decriminalized. When we look at legalization, again, I created this in late December, so other states have been added, including Illinois. But it all comes to the question, why are we required to ignore state and local marijuana laws? A lot of times when people come up to me, they'll say it's the Drug-Free Schools and Campuses Act, and yes, that is part of the answer. But there really is more of a complex answer, and that complex answer is it really delves into the Controlled Substances Act of 1970, the Drug-Free Workplace Act of 1988, the Drug-Free Schools and Campuses Act, Edgar 86 of 1989, and then also the American with Disabilities Act comes into play and reinforces those three acts as well. For those of you that may not have a substance abuse background, The Controlled Substances Act was passed in 1970. It was part of the legislation that Nixon promoted and passed. Its actual title is Title II of the Comprehensive Drug Abuse Prevention and Control Act of 1970. And what it does is it basically classifies different substances into different schedules. Since the creation of this act, there have been substances that have been added, substances that have been removed, and substances that have been moved around from schedule to schedule to schedule. So on one hand, when there is discussion of let's decriminalize marijuana, let's delegalize marijuana, let's move it to another schedule, there have been some precedents that has been done with other substances before, so it is a possibility. Others will sit there and say, you know, it took the court 22 years to come up with an initial judgment. How long will it be for them to go through that process again if they will end up moving marijuana to a different schedule? Currently, marijuana is a Schedule I drug. Typically, when we think of Schedule I drugs, it includes things such as heroin, LSD, ecstasy, and cannabis. When we think of these drugs, they really are not seen as having any acceptable medical use in the United States, that if there is a lack of accepted safety under medical supervision, and as well as a high potential for abuse. And again, right now it is a Schedule I drug. When we look at Schedule II, they're typically substances that may be seen as being acceptable for medical use in the US. They're accepted safety levels for use under the supervision of a medical provider, but they may also have a high potential for abuse, which could lead to either physiological or psychological dependency. When we think of those drugs, you know, it's the meds that you might get if you were in a hospital: morphine, codeine, oxycodone, methadone, possibly some amphetamines, such as Adderall if you're have been diagnosed with ADHD, Ritalin, those types of drugs. Schedule III has less potential for abuse than the substances in Schedule I or II. Abuse may be moderate or low physical dependence or high psychological dependence. And usually those are things like Tylenol with codeine or anabolic steroids. Schedule IV has lower potential abuse, and that would include things such as Xanax, Valium, Halcion, clonazepam. And Schedule V, which is the lowest schedule, really low potential for abuse, but some potential for abuse. And usually would be medications that have very limited amounts of certain narcotics. So the popular one of this schedule would be Robitussin AC. Interestingly, when we think about alcohol and tobacco are the two substances that are not controlled. So one of the things that I like to encourage people to think about is, are we trying to treat marijuana similar to alcohol and tobacco? And if we are trying to treat marijuana similar to alcohol and tobacco, is that possible based upon the fact that the federal government still maintains cannabis as a Scheduled I drug? And if we're trying to treat it similarly to alcohol and tobacco, what implications does that create for us? One of the questions that I get asked a lot is, will marijuana be reclassified? Will it be delegalized? My thought on the matter, and again, this is my thought, is I think it's going to be real difficult to move a drug from a Schedule I to completely nothing and move it to the classification of alcohol and tobacco. I can see it moving to a Schedule II where it is permitted for medicinal use, but recreational use is not. I think some will see that as a compromise. For us in higher education, I think that move, if it were ever to occur from Schedule I to Schedule II, would create a much bigger mess for us, because how would we be able to determine and discriminate that a student's use is actually medicinal? How do we get that documentation? I think it's just going to be a real big mess if that move to Schedule 2 were to occur. In addition to the Controlled Substances Act, we have the Drug-Free Workplace Act of 1988. And it basically requires federal contractors and requires all federal grantees that they provide drug-free workplaces as a precondition of receiving a contract or a grant from a federal agency. Many of us in higher education have research and sponsored program offices. We have faculty and staff who receive federal grants outside of the Title I funds that many of, if not all of us, receive. So all of us probably are required to comply with the Drug-Free Workplace Act as well. A lot of times people believe that the policy notices that are required by the Drug-Free Workplace Act are the same as the notices required by the Drug-Free Schools and Campuses Act. They are two separate policy statements. They both have different requirements of the content that is to be included in those policies. So a lot of times HR will be the entity that takes care of the Drug-Free Workplace Act. Some student affairs entity usually oversees the Drug-Free Schools and Campuses Act. So it's important to make sure that those parties that oversee the compliance with those two acts are communicating with one another and making sure that all the bases are being covered. As a requirement of the Drug-Free Workplace Act, must maintain a drug-free workplace. So again, going back to Schedule 1, cannabis use is not allowed on campus. Impairment should not occur during the workplace. Most of us are organizations, so our requirements differ than those contractors or grantees that are an individual, and the organization basically requires more extensive compliance. So we have to have a comprehensive program to achieve a workplace free of drugs. A lot of times higher institutions of education will have an employee assistance program, a referral program to where if employees are having difficulties with substances, they can refer them out to counseling. But a comprehensive program is really more than just a referral system. And this is where hand in hand with the Drug-Free Schools and Campuses Act, we not only need to be educating and targeting our students, but we need to be addressing our staff and faculty as well. The Drug-Free Workplace Act covers both temporary and full-time employees. So one of the things that many institutions may not have thought about is if we have student employees, they may also be covered by the Drug-Free Workplace Act in addition to the Drug-Free Schools and Campuses Act. Students who are receiving Pell Grants are expected to comply with this act. So even if they are not an employee, they are expected to abide by these requirements. There is not an exemption for educational related grantees, and that there must be an ongoing program. So it has to be more than just a one-time shot approach. It must be comprehensive, it must be continuous, it must be ongoing. The employers do get to choose whether or not alcohol or non-prescription drugs are included. So at this point in time, cannabis being a Schedule I drug would be included. If cannabis were to be rescheduled or completely decriminalized or delegalized at the federal level, it would be interesting to see how this particular act might be modified to accommodate that change in policy. At this point in time, the only reporting requirements pertain to convictions of unlawful use possession in the workplace. So a lot of times if an employee has been found to be using, they probably get referred to the EAP program. There's probably not a law enforcement interaction, and it's mostly handled that way. So that may not be a reporting requirement. If an institution is found not to be in compliance with the Drug-Free Workplace Act, it's very similar to other acts. Grants or contracts might be suspended. they might have to pay back, or the grantee might be prevented or prohibited from future opportunities for funding. Then we come to the Drug-Free Schools and Campuses Act. Basically, many of you are probably aware of it. It says, as a condition of receiving funds of any form of financial assistance under any federal program, we must certify that we have adopted and implemented a program to prevent the unlawful possession, use, distribution of illegal drugs and alcohol by students and employees. There are really 3 additional requirements in addition to the certification. One is that we have a substance abuse program. Program is very hard to define, unlike CLARI, unlike the Violence Against Women Act, unlike the SAFE component of CLARI and Title IX. The federal government has really not gone into great detail as to what a substance abuse program should look like. There is the letter of the law and the spirit of the law, and this is one of those laws where the spirit of the law really prevails. Our guidance is actually over 14 years old. It is outdated. There is nothing on the horizon that indicates that the Department of Ed will be changing these requirements or modifying it at all. What does the program look like is content for another webinar, or our Drug-Free Schools and Campuses Act training that we'll be offering later in the semester. There's also an annual drug and alcohol prevention program notice that must be sent to all students, staff, and faculty. Every staff, faculty, and student should get that notice at least once every 12-month period. I would encourage everybody to be looking at their policies, particularly with the changes of the state laws, and thinking about how they integrate the changes outside of our environment into that notice. And then we also prepare a biennial review of our prevention programs and policies and how effective they are. Now, one of the questions that has come up is, will an Institute of Higher Ed lose funding for Drug-Free Schools and Campuses Act violations and marijuana policy changes? Now, this is 8 years old. There's an organization called Students for a Sensible Drug Policy. When they wrote this document, it was around 2012. And at that point in time, the Department of Education was just beginning to increase its monitoring and enforcement of Drug-Free Schools and Campuses Act. So at that point in time, they could literally say that there have been no institutions that have had federal funding affected or impacted as a result of non-compliance. There is probably a degree of truth into that statement. I'm not aware of any institutions that have had Title IV financial aid funding withheld as a result of non-compliance, but I can say that over time, institutions have been being monitored, they've been being audited, and they've had to go into corrective action plans, as well as have been receiving financial penalties. I was at the Stetson Law Conference last week, and one of the colleagues that I have there indicated that the feds actually increased the penalty for violations of the Drug-Free Schools and Campuses Act and the CLARI Act and other similar measures up to $57,000 per violation. So, you know, it can hit the checkbook pretty hard. The other act that comes to play that I think is one that many of us don't know a lot about, but I think it really does impact how we move forward with addressing marijuana on campus, particularly with relationship to medical marijuana, is the American Disabilities Act of 1990. The ADA is a civil rights law that basically prohibits discrimination against individuals with disabilities in all public areas. And it's really intended to make sure that those with disabilities have the same rights and opportunities as everyone else. And it provides some protections to individuals with disabilities similar to other protections with individuals for other civil rights areas such as race, color, sex, age, origin, those types of things. The ADA is broken up into 5 sections, and the section that pertains to this conversation and the use of cannabis is within Title V, and within Title V, there's a provision that deals with the legal use of drugs. And basically what that ends up saying is that if an individual has a disability, any use of illegal drugs basically eliminates that. Being that marijuana or cannabis is a Schedule I drug, the use of that is illegal, and therefore there is no legal provision to provide accommodations. So for example, if a student comes to your campus and says, I have my script for medical marijuana, you need to give me an accommodation. The federal law based upon the Controlled Substances Act, the Drug-Free Schools Act, the Drug-Free Workplace Act, and the American Disabilities Act basically says this is an illegal activity. We do not have to accommodate that. Probably the greatest area where this comes to play would be for campuses that have an on-campus residency requirement for the first year, for the first 2 years. Some campuses have allowed students to waive out of those contracts based upon their medical cannabis use. That is probably a decision for all campuses, but based upon the current foundation of the law, there is no requirement for you to medically accommodate a student's medical marijuana use. So when we sum it all up, marijuana use is against federal law. There are 4 acts which really apply to us in terms of how we view marijuana. These laws basically apply to all instances of events and activities that occur on our campus property, as well as any event that is held off campus that is considered official. So for those of you that may end up allowing faculty to take students on field trips, just because they're not on the physical property of campus, if it is an officially sponsored and endorsed activity, the federal law still applies. In some aspects, nothing has changed for us. So unless marijuana becomes an uncontrolled substance, even if it gets a lower classification, we're still going to have a discrepancy between what the feds are saying and what many of our current states are saying. So when we look at what has upheld in the courts to provide some foundation, which may give us an indication of what changes we may or may not see. Again, since the 70s, marijuana has been battled whether or not it should be continued as a Schedule I drug. There have been petitions, there have been hearings, it's gone to court. And at this point in time, the decision to maintain it as a Schedule I has been upheld. Do we use that as a foundation to look into the glass ball to determine whether or not it will be decriminalized, legalized, or rescheduled in the future? It's really hard to say, but if we look at the past, any conflict that's been used to try to move it has not been successful. Whether or not, states' rights versus national rights, where does it hold? In 2001, Oakland Cannabis Buyers Cooperative basically legalized marijuana for medicinal use, California passed Proposition 215, and the government sued this cooperative. And basically, the Supreme Court unanimously ruled that there was no medical necessity exemption to the Controlled Substance Act's prohibitions on manufacturing and distributing marijuana. So, you know, marijuana is marijuana. Marijuana is Schedule 1. Marijuana is illegal. One of many initial court cases reinforcing that. Gonzalez versus Reich in 2005, a group of medical marijuana users argued that the Controlled Substance Act basically exceeded Congress's Commerce Clause ability, and that it was unconstitutional. The Supreme Court reviewed the case in a majority, said that even where individuals and businesses in accordance with state-approved medical cannabis programs were acting lawfully, that would be a violation of violating federal marijuana laws. Part of the findings of that argument were also that you know, it's kind of hard to distinguish medical marijuana from illicit marijuana use, and that interstate commerce contributed to interstate commerce. When we look at higher education, there was one court event that did not see its way through the entire court system. The university dropped the charges and kind of settled out of court, but there was a student who got in trouble for having 2 ounces of cannabis in his residence hall. He had been a caregiver for a sibling and basically had it in his possession to help his sibling with their medical ailments. And that was one of the first schools that publicly waived the on-campus residence requirement for students with medical marijuana prescriptions. They felt that that was a better agreement to come to than to go to court. James versus City of Costa Mesa. Basically, James and others had previously acquired medical marijuana. The city then prohibited the sale of the marijuana, and they sued the city based upon discrimination under Title II. And the courts came back and again said, it's a Schedule I drug, it's illegal. You can't be discriminated against for doing something that is illegal. Coates versus Dish Network. For those of you that focus more on the human resource side, this may be of interest to you. Coates was an employee of the Dish Network. He basically used cannabis in his off hours work. And then they ended up drug testing him for some reason or another, found the substance within his body, and they fired him. And he came back and said, you can't do this. I did this on my personal time. I wasn't at work. But basically a district appellate in the Colorado Supreme Court basically said, yes, Dish has the right to terminate you for your use outside of work hours. So there's this precedent legally that we have that kind of has set the stage for where we're at and where we're going. So as we think about higher education, nothing has changed, but to reference the book Who Moved My Cheese, the cheese has definitely moved. What I've seen in the last 6 to 12 months is that in Illinois, many of our campuses have actually started looking at their policies to highlight and clarify the difference between federal and state laws. If your institution has not started that process, has not initiated that process, I would highly recommend you to do so. It just makes, it's a wise decision. In looking at your policy, I would be sure to cite the discrepancy between federal laws and regulations. And this really needs to extend not only in your policies, but also your education, your new student orientation, your parent programs, probably some of the marketing materials that you may be using to attract and recruit new students. the content of information provided to potential international students. We probably need to be thinking about this more holistically than just the policy that we're looking at. The other thing that I would encourage people to think about is what constitutes an official event, what constitutes an official activity. Basically, when our students, staff, and faculty leave our campus boundaries and they're out in the greater community or the greater world, where would they be allowed to take advantage of the state or local municipality rules and be able to use without violating an institutional policy? And then where would they not be able to do that because it is still considered an institutional event, an institutional activity sponsored and endorsed by the institution? One of the other things that I've seen a lot of times and had some conversations with is when we are updating our policies, we need to think about all forms of cannabis use. I hear a lot, oh, well, we don't have to really worry about, that issue on our campus, Eric, because we have the Smoke-Free Campus Act. Well, that will handle your smoked forms of cannabis, but you really need to think about your edibles, you need to think about your vapes, you need to think about your oils, sprays, tinctures, wax, hash oils. A lot of times we think of cannabis use that was popular when we were younger, and we're not as up to date on the new varieties and forms of cannabis use. So when you're thinking about policies, how do you address edibles in a residence hall system? How do you address CBD? Do you address CBD? Especially when a student can just walk across the street and go to a local former movie rental place and get all the CBD that they want from there. It's also important when you're thinking about policy and thinking about the education of your students is what does enforcement really look like? How are you going to monitor it? How are you going to sanction it? For the most part, what I'm seeing is that many of our campuses are not altering their sanctioning processes. Many campuses are referring students to an on-campus student conduct board or a dean of students. The students are getting sanctioned through that means. Enforcement may be a little bit different. Some campuses are still contacting university police or security to handle the issue. Others are letting the housing staff, if it's a residential campus, to handle the issue. But you need to think about what process you will be doing. Likewise, you need to think about off-campus policy violations. If you have a student that is 19 who goes off campus and is basically cited by the municipality for underage use of cannabis, and they refer that back to you or you become aware of it, how are you going to handle that situation? A lot of campuses are handling off-campus policy violations for alcohol. My advisement would be, however you are handling the off-campus policy violation, you probably need to think about doing that for the cannabis. So if you don't deal with off-campus violations of alcohol, then you probably don't want to deal with off-campus violations of marijuana. But if you attend to and address the off-campus alcohol policy violations, you probably need to think about addressing the off-campus marijuana policy violations. And again, as an institution, you really need to clarify your intent of what you're going to do regarding the local and the state policies. And again, education is key and important. I think there's a lot of misconceptions that like, oh, I can smoke pot, I can do this, it's okay. Well, Illinois does have some certain aspects to the law, such as you have to be 21. There's a certain amount that you can have for personal use. You can't sell it. You have to be licensed and certified as a distributor. Otherwise, selling my edibles to my friend, I have essentially become a drug dealer. And if I'm caught for that, and if I want to be prosecuted, I could be prosecuted to the full extent of federal law. Those are things that our students probably aren't thinking about. In terms of policies and examples that you might consider, I really like what Skidmore College has done. And if you look at your screen right now, you will see a screen capture of what is in their student handbook. And they basically say use, possession, cultivation of marijuana for medical purposes is not allowed. Use of marijuana is strictly forbidden and subject to action under the Student Conduct Code. And they talk a little bit about how in New York State, the state law does permit medical marijuana, but at this time, federal laws prevent that. But they also include in the statement that if a student is using medicinal marijuana, they can apply for a waiver of the on-campus residency requirements. But if a student chooses to live on campus, even with a prescription, they can't have that on campus. Rhode Island School of Design is also another policy that I really like. They reference the Controlled Substances Act. They indicate that a medical marijuana certificate provides no immunity against federal prosecution. They give an explanation of the federal laws and why the school has to take this stance. And basically, if you're going to use medical marijuana, you have to use it off campus. If the student's required to live on campus, they can request a waiver off campus as well. Oregon State has evolved their policies. I like their policy really well because they really lay out the Drug-Free Workplace, the Drug-Free Schools and Campuses Act. They give a good example and a description of that. They state that marijuana can only be used recreationally for those that are over 21 years old. And then they talk about drugs, and they include marijuana as they would address any other illicit drug. Now, in the past, Oregon State had slightly different policy. So they talked about how marijuana use would be prohibited in residence halls and dining halls, as well as how they prohibit the possession of marijuana-related paraphernalia, and what would happen if the marijuana was discovered by the university. Some other things that I liked about Oregon State is that they will not advertise, promote, or otherwise coordinate student internships, research, or job opportunities with companies involved in the manufacturing, distribution, or possession of marijuana. It creates a great conversation because federal law says this drug is illegal. We shouldn't be promoting its use. We shouldn't be allowing its use. So when you think about job postings, you think about internships, you think about partnerships with cannabis-related businesses. Are those things that as institutions of higher education, which are federally funded, should we be engaging in that work? Should we be pursuing that work, or does it actually violate the federal mandates? A lot of people have a lot of different opinions about that. I tend to be more conservative and say, I think what Oregon State has listed makes a lot of sense. When we look at what they had in 2016, they talked about student code of conduct. They had a statement about human resources. One of the things that I also liked is they talked about academic instruction and that the faculty will not instruct students during class or through class materials how to grow, manufacture, distribute, or dispense marijuana. Oregon State saw that as a discrepancy that did not align with the federal legislation. And likewise with the research, they basically said if we're going to do research using cannabis, we're going to be following the guidelines set by federal agencies. As you can see, there are a lot of implications regarding policy as to this current situation. We've talked about the the on-campus residency requirements. As a campus, you will have to decide whether or not to do zero tolerance or waivers. Medical clinics currently, most, if not all doctors I know, are not agreeing to write prescriptions for medical marijuana, saying that it is a violation of federal law. They don't want to lose their federal licensing. But if marijuana were deregulated, moved to a lower class, or completely legalized, that may be something that as a campus, your medical clinic and your medical staff will have to think about. Communication is key. How are you communicating to current students and families? How are you communicating to prospective and new students and families? I think the longer that our state law is in effect, legalizing medical marijuana and legalizing recreational use, we're going to have families coming to campus saying, well, what's the big deal? Why are you being such sticks in the mud? Why do you have to do this? And we're going to have to be really prepared to be able to explain why we are doing things the way that we're doing them. In addition to current staff and faculty, I think one area that many of us are probably missing the boat in is how are we communicating this to the public, particularly those guests that come to sporting events, those guests that may come to camps and conferences that are held on campus throughout the year. We're probably not doing as great of a job communicating to those entities as we need to be. And then also, how do we communicate to prospective and new staff? I think it's important to have your campus do what it says it will do. So if you say we are going to be monitoring this and enforcing this, then it's important that you be doing so. You don't want a disagreement between what you say you're doing and what you're actually doing. You'll have to think about, what does that mean if we have a campus community member that's in violation of the policy compared to a guest or a member of the public visiting campus? Many of you in Illinois have a smoke-free campus policy. It may make sense to look at that and see how you have addressed tobacco use with different entities on campus. And if it's worked, maybe apply that to the marijuana. And again, many people may think of marijuana as smoked form, but there are other forms that need to be considered. What do campus sanctions look like versus local sanctions, state sanctions, and federal sanctions? Are they in alignment? Are they in disagreement? There's always a concern that if we have lesser sanctions on campus, it may push use on campus. If we have harder sanctions on campus, it may push students off campus, and that's always a delicate balance, particularly in times where enrollment may be down, students moving off campus, those types of things. Again, a lot of people have said, well, let's view cannabis like we do alcohol. Let's treat it like alcohol. And I think the main thing I would encourage folks to remember is that marijuana is a controlled substance. It is something that, we are expressly forbidden to allow and prevent, and that alcohol and tobacco are not controlled substances. And that creates a big difference in how we should perceive these substances. When we think of other implications, it's a program to prevent the unlawful possession, use, or distribution of illicit drugs and alcohol by students. So what does that mean when we have a curriculum or a course that wants to partner with someone in the cannabis industry? What does it mean when the cannabis industry wants to start advertising in our paper, and there ends up being events, and those events are covered by our reporters through our student media? It'll be interesting to see how this plays out. This area is probably the one area that there is some tolerance for, and that is basically as a result of the right of free speech superseding a lot of the other rights. whether it be the right of a business or a right of an individual. So when we look at alcohol advertising in college newspapers, for example, a college newspaper can't ban alcohol ads as a result of the Drug-Free Schools and Campuses Act. Part of that probably stems from it not being a controlled substance, but more importantly, it relates to the First Amendment. As we move forward, it's important for us to address it, and it's going to change how we address cannabis use. I always encourage a social ecological framework where we are looking at a variety of interventions that address individuals, social networks, the organization, the larger community, as well as public policy. When we think of individuals, we're really looking at a lot of our educational efforts, what we pretty well think of when we think of prevention. When we look at interpersonal, we're looking at how the networks influence each other. Social norms is a strong component of an interpersonal intervention. Organizational is when we look at how the organizations work, the student organizations within our community, and how they impact one another. The community is our larger organization, and then public policy really refers to local, state, regional, and national policies. When we look at individual interventions, there are some things that seem to be more effective and having an impact. Many organizations nationally within the college arena promote a focus on harms. So talking about how use can impair driving, the dangers of edible versions of cannabis, and how quickly the intoxicating effects of the drug may take effect, or how slowly it may take effect compared to other forms, how it affects academic performance, how it affects brain development, and the risk for cannabis dependence. Some states are looking at harm reduction for those over 21, similar to the types of harm reduction strategies that may be used for alcohol. There has been a strong push for screening, brief interventions, and referral to treatment. Experts using the cannabis use disorder inventory test in medical settings or in judicial settings. Many of you are probably familiar with BASICS, which is the brief alcohol screening and intervention for college students. There is a variant called K6, which really focuses on marijuana use. Both of those programs have been very popular and are considered gold standards within higher education, coupled with motivational interviewing and enhancement. San Diego State University has created a normative feedback online survey for alcohol called the Checkup to Go. They have created a marijuana variant, and Colorado State did some research on that intervention a few years ago and found it to be very effective at impacting individual use. And then with the current movement of legalization, there is a trend and a push to do more research on protective behavioral strategies that would coincide with harm reduction strategies. For the interpersonal level, when we're talking about groups, again, looking at social norms interventions, descriptive norms, injunctive norms, and applying a marketing strategy for that has been really strong. Bystander intervention has also been used by the folks out in Colorado. Organizationally, the environment is changing. I know that there are a lot of surveys that we are required to do, but I would encourage organizations to consider doing needs assessment around cannabis use. What are your students doing? Where are they doing it? What are their beliefs, attitudes, and values? And I would also encourage campuses to think about asking their students what they really know about the current laws and how those laws affect to them. You know, do they perceive it that it's like, hey, I can do anything I want, or, you know, they realize, oh, okay, I'm not 21 yet, legally I can't do this, or I can't do this in the open, I can't do this in public. What are the laws? And then in addition to our students, I would also say our faculty and our staff and our administrators need some education and training. I always like to use the phrase, it's not my grandfather's pot any longer. There are a lot of variants of cannabis use, some that my grandfather probably would have never even dreamt of. And if I'm living the world through my grandfather's eyes, I'm falling behind very quickly. In terms of community intervention, what I would say is, Title IX, VAWA, SAFE, Clery, those are the well-known mandates. I typically refer to the Drug-Free Schools and Campuses Act as the forgotten mandate, although that's changing. But we need to put our efforts for Drug-Free Schools and Campuses Act on an equal footing, particularly with marijuana and cannabis use, with those other federal acts that we're required to comply with. I would encourage data collection. Several of you looking at the list are in schools that participate in the core alcohol and drug survey that IHEC administers. If you're an Illinois institution and you would like to do a population-based drug and alcohol survey, please call Aisha, our assistant director. We still may have some room for some schools to engage in that statewide survey at little to no cost this spring. But in addition to self-reported use and data use, do you have data through your health services, your counseling clinics? Are your security and law enforcement collecting data? Are you looking at the number of violations and arrests and referrals to treatment organizations? Just keeping data to get a feel for what's going on and where you're going. And that data collection is really considered a part of a biennial review process. So by doing this, you're not only helping yourself figure out what's going on campus, but you're also helping your institution meet part of that biennial review process. Sometimes when I talk with colleagues on campus, and I'm sure many of you probably have similar conversations, is, oh, we have a smoke-free policy. That'll handle our marijuana. Smoke-free policies are not enough, especially when we think about edibles and forms of CBD. I think it's important to review our conduct codes and make sure that we're not only addressing edibles and smoke, but e-cigarettes and vapes, that we're looking at ADA issues and clarifying that this is an illegal substance and you can't be accommodated for an illegal activity, as well as looking at employee use, liability risk, and our risk management efforts. We need to be doing more than just on-campus work. We need to be talking with our local district and state's attorneys. We need to be working with our local enforcement to figure out what's going on off campus. How is it being monitored? How is it being sanctioned? How is it being adjudicated? What happens when one of our students gets in trouble off campus? Probably one of the biggest areas nationally that we need is practical testing methods. Testing is not at the level to where it is with alcohol. We have a long way to go. And that is one of the barriers that we have. We may also want to think about limiting the marketing of adult use marijuana that targets our youth and our other vulnerable populations. We know from science that when younger students perceive a substance to be less dangerous, less harmful, less risky, that use tends to go up. And I would imagine that many of our colleagues in K-12 prevention are seeing that trend happening, and ultimately those students are going to come to our campuses, and whatever behaviors, attitudes, and beliefs they've already created, they will bring those with them. We may also want to think about levying local taxes as more of the cannabis industry evolves and plants itself within our communities. That may be a regulatory measure that may have a promising impact in terms of prevention. We know from the research that increasing alcohol taxes typically reduces use. I imagine the same would be said with marijuana and cannabis use. We probably also need to work with our communities to limit the number and density of alcohol use marijuana retailers. We know that increased accessibility and availability increases alcohol use. We can generalize that to what we see coming down the trail with cannabis. We may also want to think about working with our local communities to only allow specialized businesses. So that way we don't have cannabis in bars and grocery stores, convenience stores, former video stores, all of those types of things. And then one other thing that I would recommend would be bud tender training, similar to responsible beverage service training. I think that is really needed, particularly as the commercial models begin to evolve and expand. There are also things that we can do to promote some good public policy at the state level. Prevention is always needed and a must. Again, the bud tender training, similar to responsible beverage service training, would be important. Things such as packaging and warning labels, different types of protective measures for containers. Really, we should be looking into that, investing and seeing what science says about those types of interventions. Nationally, until there is some finality to what is going on and whether it will remain where it's at as a substance, that's going to be key. But we also need to think about a national need for uniform reporting among all of us. Clary probably comes closest to that, but then again, it's all latched together in general substances. We've covered a lot of ground in a very short time, and with that, I would be more than willing and happy to take any questions that any of you might have. Tracy has asked, will participants have access to the PowerPoint? Definitely. We will go ahead and PowerPoint we will PDF the PowerPoint, and this is also being recorded. So if you have colleagues on your campus that may have missed it, we'll also make the recording available as well. Other questions? We have unmuted everybody in the event that any of you have any questions that you would like to ask verbally. There is a question. Do we have a policy regarding the Drug-Free Workplace Act? I will find, I know Eastern has that online, so I can find that URL, and we will make sure that we get that out to everybody as well. We'll probably also try to PDF a copy of that and be able to distribute that to you all. Very well. Grace, I believe it looks as if everybody has asked the questions that they have, so I will let you go ahead and conclude us.
Okay, perfect. Thank you. So I just want to tell everyone to please keep an eye out for an email from GoToWebinar that will come about an hour after this concludes. The email will have a link for you to fill out an evaluation. This evaluation will help us with the planning of future events. And then as for certificates, they will be issued within 7 to 10 business days from the webinar. And we will have the webinar available, as Dr. Davidson already said, to view on the IHEC website. And thank you, Dr. Davidson, and everyone that came today.
Very good. Thank you.